three. 1, 2, 3, start.
When the voice of the people is weakened by the power of politics, by the negligence and the power, there arises a judiciary which stands alone as the concise keeper of the judiciary and maintains a democracy. Judicial activism is not interference, rather judicial activism is a fulfillment of the constitutional morality, says a group of senior advocates. A very warm afternoon to one of our present here, respect jury panel, fellow debatemates and their audience. Today, I stand before you all to speak for the motion of the topic and say judicial activism is a guardian for democracy. So far, 21 fellow debatemates have spoken so far and have presented their argument stating that judicial activism is overreaching our democracy. But I state that I present my argument like they have not done a proper research. Let me give a very proper example. Most of the people are mentioning that it is overcoming or it is overreaching the democracy. At the same time, there are many instances where the judicial restatement has been maintained in the Indian Constitution. Let me give one particular case example. When Narmada Bachao Andolan was taking place, when this team was making some group of discussion to protect this Narmada river and so that they can protect the nature, even the central government has stated supporting some cases. When this public interest case was appealed in the Supreme Court clearly mentioned that the legislative and the executive resolutions which have been passed, they are very clear. There is no stance for us to take. We will leave this matter to the government as the motions are clear. In this situation, the judicial impeachment, what the fellow departments are arguing, it has been not taken. Rather, the judicial restatement has been maintained with the judicial system, what most of the people will argue. Now, let me give me few instances like how actually this judicial activism is upholding our democracy. Dear audience, we know about the electoral integrity. When I talk about the electoral integrity, still before 2013, there was no mention of the nota. That is none of the above option. But our Supreme Court intervened in this case and it ordered the Election Commission to introduce the option of none of the above. Why you know? Because in order to improve the quality of democracy. Now let me tell you how actually it will improve the quality of democracy. When the none of the above option was introduced, now the political parties will think twice before candidating their candidates for the elections. Because unless we don't know that these people characters, we cannot question them. Now the people has an option. If the candidate who have been participated from that particular party, if he feels that he is not eligible, obviously people will choose none of the above. If that right has been before came because of the intervention of the judicial system. And let me talk about the transparency in the democracy. It has been increased, my dear friends. I strongly feel that the democracy will die in the darkness if the citizens we do know who are funding our political leaders. You know this Electoral Bond Act. Recently, it amended that who are funding our political leaders. Once we know who are funding our leaders, we can easily understand what is actually happening, who are funding political leaders, what are their ideologies. And next thing is the Supreme, when the PI, that is public interest litigations, have been filed in order to expose the criminal cases upon the political party candidates who are fighting in the elections, when the Supreme Court ordered the Election Commission to expose, to expose the details of the political candidates who have been contesting, so that the criminal records will be, let it be open for the public. So let them think, if so many criminal cases are there on that particular political candidate, let the people decide whether they need a criminal to be to enter the legislative system and frame the laws. A political candidate who himself is a criminal, can he make any laws? Right? And now may say that it is overreaching and it is intervening. My question is very clear, dear audience. When the legislative and executive body performs very well without any fuss, I don't think so. There is need of the judicial system to intervene. Since the legislative body and the executive body is not performing well, and there was voids in the rules they have made, so the judicial system has intervened. If you take this Shikar case, which have been explained, many people are expressing about women harassment for 50 years. We got independence in 1947 till 1997. There was no law protecting this. When such is the situation, Supreme cannot sit down, still more 15 years, or let Parliament decide and the law. So lastly, I would like to conclude that this judicial activism is not about the stealing of power. Rather, I feel that it is increasing, filling the voids which has been not maintained and which has to be supposed to be maintained with the legislative and the executive body. So I strongly feel judicial activism is a need of an hour. When the legislative executive body sleeps, judicial activism needed to awaken all these people and bring the light and bring the judgment and justice for the lowest people, because Supreme Court is the last hope for everyone. Thank you.